F. And I quote, "From the foregoing analysis, it appears unlikely that a court would hold that Congress has expressly or impliedly authorized the National Security Agency electronic surveillance operations here under discussion, and it would likewise appear that to the extent that those surveillances fall within the definition of electronic surveillance within the meaning of FISA or any other activity regulated under Title III, Congress intended to cover the entire field with these statutes." This from the presidential authority to grant warrantless electronic surveillance to gather foreign intelligence information provided by the Congressional Research Service on January 1st, 2006. G, quote, and this in a letter from Harvard Law Professor Lawrence Tribe to Chairman John Conyers on January the 6th, 2006, quote, "The inescapable conclusion is that the authorization for the use of military force, it's relating to the attack on Iran, did not implicitly authorize what the FISA expressly prohibited. It follows that the presidential program of surveillance at issue here is a violation of separation of powers, as grave an abuse of executive authority as I can recall ever having studied," unquote, Harvard Law Professor Lawrence Tribe. H, on August 17, 2006, Judge Anna Diggs Taylor of the United States District Court in Detroit in ACLU versus the National Security Agency ruled that, quote, "The NSA program to wiretap the international communications of some Americans without a court warrant violated the Constitution." Judge Taylor ruled that the program violated both the Fourth Amendment and a 1978 law that requires warrants from a secret court for intelligence wiretaps involving people in the United States. She rejected the administration's repeated assertions that a 2001 congressional authorization and the President's constitutional authority allowed the program. This from a New York Times article, Judge finds wiretap actions violate the law, 8/16/06, or strike that, 8/18/06, and the memorandum opinion. I. In July 2007, the Sixth Circuit Court of Appeals dismissed the case, ruling the plaintiffs had no standing to sue because given the secretive nature of the surveillance, they could not state with certainty that they had been wiretapped by the NSA. This ruling did not address the legality of the surveillance, so Judge Taylor's decision is the only ruling on that issue. In all of these actions and decisions, President George W. Bush has acted in a manner contrary to his trust as President and Commander-in-Chief, and subversive of constitutional government, to the prejudice of the cause of law and justice, and to the manifest injury of the people of the United States. Wherefore, President George W. Bush, by such conduct, is guilty of an impeachable offense warranting removal from office. Article 25. Directing telecommunication companies to create an illegal and unconstitutional database of private telephone numbers and emails of American citizens. In his conduct while President of the United States, George W. Bush, in violation of his constitutional oath to faithfully execute the office of President of the United States, and to the best of his ability, preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty under Article 2, Section 3 of the Constitution, quote, to take care that the laws be faithfully executed, has both personally and acting through his agents and subordinates violated the Stored Communications Act of 1986 and the Telecommunications Act of 1996 by creating a very large database containing information related to the private telephone calls and emails of American citizens. To wit, the President requested that telecommunication companies release customer phone records to the government illegally, as evidenced by the following. Quote, the Stored Communications Act of 1986 prohibits the knowing disclosure of customer telephone records to the government unless pursuant to subpoena, warrant, or a national security letter or other administrative subpoena, with the customer's lawful consent, or there is a business necessity or an emergency involving the danger of death or serious physical injury. None of these exceptions apply to the circumstance described in the USA Today story, unquote. This is from page 169, George W. Bush versus the Constitution, compiled at the direction of Representative John Conyers. According to a May 11, 2006 article in USA Today by Leslie Cowley, quote, the National Security Agency has been secretly collecting the phone call records of tens of millions of Americans using data provided by AT&T, Verizon, and Bell South. An unidentified source said the agency's goal